Good morning, everybody, and welcome to the fourth in our series of webinars for Safe Work Month 2021. This morning's topic is Work Health and Safety General Regulations 2021. So this is your opportunity to ask questions about the incoming regulations as they apply to general workplaces. We have an excellent double act for you this morning. Assisting us and hopefully answering questions for you will be Bill Mitchell. Bill has a postgraduate qualification in business law and more than 20 years experience in policy development. He's currently the General Manager for the Work Health and Safety Reform Team and has actually been involved in the harmonisation and modernisation of the legislation since 2008. So he's been there from the very beginning. Assisting Bill is Andrew Cockgreave. Andrew's a Senior Policy Officer with the department, and he's been with WorkSafe since 2008 as well. He's been involved with the harmonisation process since then, and he was actually the instructing officer for the WHS Act 2020, so he actually sat on the floor of Parliament assisting the Minister as the bill was debated. He's been heavily involved in the drafting instructions for the regulations, so he's had a great deal of involvement in that also, and just interestingly has qualifications in film and television, but tells me he would much rather be behind the camera than in front of it. He's in front today. Just before we begin, the department would like to acknowledge Aboriginal and Torres Strait Islander people as the traditional custodians of the land on which we deliver our services. We pay our respects to elders and leaders past, present and emerging. Just before I hand over to Bill to get us underway, I will just remind you that your interaction today, questions should be submitted via Slido. Please don't post them up on GoToWebinar because we won't see them there. And today's presentation is being recorded, so it will be available at some point in the future on the WorkSafe website. But without further ado, over to Bill.
Yes. Thanks, Andrew, and welcome to my presentation this morning, which is about the Work Health and Safety General Regulations. Before we start the questions, I just thought I'd provide you with some background in relation to the Work Health and Safety laws. So last year in November, the Work Health and Safety Act received assent. However, the Work Health and Safety Act cannot commence until the Work Health and Safety Regulations are finalised. For the 2021 election, the government committed to adopting to implementing the Work Health and Safety laws in January 2022, so that's not very far away now. So in terms of developing its proposals for the Work Health and Safety Regulations, the government asked that DMIRS conduct extensive consultations in 2019, and this is what's happened. The department conducted presentations and consultations in regional areas and also through the metropolitan area as well. There was various documents to support that. As a result of the consultations, the government received 69 submissions from various stakeholders, not surprisingly providing many views, some consistent with each other, but of course there was some difference as well. One of the first decisions the government made is that there will be 3 sets of Work Health and Safety regulations. The General Work Health and Safety Regulations, which will effectively apply to the workplaces covered by the Occupational Safety and Health laws. There will be another set involving the mining operations and of course petroleum and geothermal energy operations. Our presentation today relates to the General Work Health and Safety Regulations. The government has given a commitment that it will be adopting the Work Health and Safety laws. These laws are consistent throughout Australia, with the exception at present anyway of Western Australia and Victoria. However, one of the things that I have acknowledged is that there will need to be some changes to those laws to reflect Western Australia's operating environment. And as I mentioned earlier, the 69 submissions that we received, they were all provided to the Minister, who has made some decisions in relation to those laws, and we are in the process now of drafting the regulations for the government. So in relation to the Work Health and Safety laws, the government also decided that it was going to maintain the existing major hazard facility laws in Western Australia and also the dangerous goods laws. In relation to the dangerous goods laws, there was also a commitment that within 2 years of proclamation there would be a review of those laws with the view to examining whether they should go into the work health and safety laws. That review will obviously be commenced once the work health and safety regulations are finalised. So the slide that I've put in front of you now lists the 11 chapters in the model work health and safety laws. As you can see, there's 11. There's also 9 schedules as well. So in relation to the general work health and safety laws, there'll be no text, if you like, in Chapter 10, which is mines, but of course for the work health and safety mines regulations, the details will be included there. So when you go through the work health and safety laws, the same numbering is consistent throughout all of Australia. So they're in relation to the model work health and safety laws, so there'll be no changes. What you might find, particularly in relation to Chapter 9, for example, there'll be a note there which says not used. And that appears a couple of times, or sometimes through the work health and safety the general work health and safety laws, but that's because of decisions made by the government, and it maintains the numbering system. So in relation to the work health and safety general regulations, there's something like 500 plus pages, and there are 700 regulations. So as you can imagine, it's quite a body of work, but it applies to Western Australian workplaces. So I'll just run through some of the changes that have been agreed to by the government, and these are going to be included in the work health and safety laws. In relation to boilers, the Western Australian Occupational Safety and Health regulations prescribe a 500 kilowatt threshold for high-risk work licences. The threshold in the work health and safety regulations is 150. So the government has agreed to increase the threshold to 500 kilowatts, so it's exactly the same as it is at present. The work health and safety regulations for high-risk work licences impose a requirement that in order for Western Australia to issue a high-risk work licence, the person is a resident in Western Australia. Under the Occupational Safety and Health regulations, we only require that those assessments are conducted in Western Australia, so you can be someone from the eastern states. The work health and safety regulations are being amended so that residential requirement is removed and effectively replaced by the requirement that the assessments are done in Western Australia. So this will increase the number of licences that can be issued in Western Australia. In relation to major inspections of registered mobile cranes, the work health and safety regulations require that an engineer is registered. In Western Australia, we don't register engineers, and the alternative that will be included in the occupational safety and health regulations will be that the engineer must be eligible for membership of the Engineers Association in Western Australia. In relation to plant designs, particularly for tower and gantry cranes, under the work health and safety regulations, if a crane is relocated, it doesn't have to be re-registered. In Western Australia, if a tower crane is relocated, the base and ties have to be registered. The work health and safety regulations will be amended to adopt the Western Australian drafting requirements. The work health and safety regulations include a requirement for plant registration to be renewed every 5 years. That particular provision will not be adopted in Western Australia. The meaning of construction project in the work health and safety regulations introduces a $250,000 monetary threshold. For Western Australia, the current threshold is where 5 or more persons are likely to be working. Once again, the work health and safety regulations will be amended to adopt the regulations in Western Australia. For health monitoring reports, the work health and safety regulations require that it is the PCBU or the employer that provides those reports to the regulator. And existing Western Australian laws, it's an appointed medical practitioner who provides those reports, and the work health and safety regulations will be amended so that the current system in Western Australia will be adopted in the work health and safety regulations for Western Australia. I've already talked briefly about boilers, but in terms of the high-risk work licences, the high-risk work licences go from 3 classes in the Occupational Safety and Health Regulations down to 2. And the restriction in relation to the standard class, which is in the Work Health and Safety Regulations, is that it is limited to multiple fuel sources. Under the existing Occupational Safety and Health Regulations, some intermediate classes can operate multiple fuels, boilers capable of being fired, boilers capable of multiple fuels being fired. Anyway, sorry about that. Anyway, the Work Health and Safety Regulations will be amended so that those operators of the intermediate class can continue to operate the boilers they do at present. For the electrical regulations, the Work Health and Safety Regulations will be amended so that the Western Australian system and the reference to the electrical licensing regulations will be maintained. The Work Health and Safety Regulations do not have environmental tobacco smoke regulations or commercial vehicles. The government has made the decision that those laws will come across to the Work Health and Safety Regulations, and they will be included in the Work Health and Safety Regulations. So they'll be the same as in the Occupational Safety and Health Regulations. Although for tobacco smoke, there will be a requirement in relation to protection from second-hand smoke exposure. Rollover protection on tractors. The Occupational Safety and Health Regulations reduce the threshold from 800 kilograms to 560, and there'll be a 2-year transition period for those measures. Finally, in relation to the Boland report, the ministers, including our minister, had made a number of decisions in May this year in relation to the Boland recommendations. Safe Work Australia, the agency, and members are now going through that process to implement the minister's decisions, and this includes things like the psychosocial regulations. So the government the ministers have made their decision, and those regulations are now being developed. So in relation to the transition, Safe Work Australia produced a publication which indicated a 12-month transition for those regulations requiring transition. That's basically been the system that we've adopted in Western Australia. However, there are some notable changes, and I've already mentioned one of those in relation to ROPS. There's a 2-year transition for some plant and also for noise as well, and of course there are others as well, but it's not necessarily the case that they're all 1 year, but that will be the general transition period. In terms of the Work Health and Safety Regulations availability, as I mentioned at the start of my presentation, the government indicated the intention that the laws will commence in January next year. Our expectation is that the regulations will be available in November, publicly available at that time. The commencement of the Work Health and Safety laws, as I said earlier, will be in January, and the final date for that is still to be determined, and the availability of the regulations will no doubt influence that. One of the other issues is in relation to guidance material. The department has started to provide information on the Work Health and Safety regulations, and as each day goes by, there's more and more information there. In terms of the presentations that you're now watching, and there are others as well, the webinars, they will be available after Safe Work October, and on the website there are also some on-demand videos which you can watch, and they will also be available once the Work Health and Safety, once Safe Work October has finished. So we're now going to move across to the question time. And we would encourage you to go to slido.com as the appropriate venue for you to ask questions of us. And as Andrew's already talked about, the event code is detailed on the screen, and this is an opportunity for you to ask questions. But before we go there, I will also just Whoops, sorry, no, I won't. It'll come up later. So we'll provide some information about future webinars, and we'll also talk about the contact details for the department as well. Thanks, Andrew. Okay, so, excuse me, I might just have a glass of water.
Do you want me to read them out?
So the first question is there a draft of the regulations available online for review? The Work Health and Safety regulations are based on the Model Work Health and Safety regulations. So the Model Work Health and Safety regulations are available on the Safe Work Australia website, and by and large the regulations will be consistent with those. In terms of the Work Health and Safety regulations for Western Australia, we're in the process of finalising those, and as I mentioned in my presentation, our expectation is that they will be available in November. The second question is there a transition period for implementation, and what will the dates be? So when the Work Health and Safety laws commence in January, the laws will need to be, they will be the operative laws at that time. However, as I mentioned, for some of the laws, there will be a transition period for plant and noise, for example. So there will be some transition period. What key differences will there be from the Model Work Health and Safety regulations? The WA will be, sorry.
I think the question is what will be the key differences between the model regulations and the regulations that we adopt in Western Australia. The Bill's already covered off on quite a few of those. It's fair to say that the majority of the changes that we're making, amendments we're making to the model regulations are to adopt regulations that currently apply in Western Australia. So I think Bill's already mentioned protection from tobacco smoke and commercial driver fatigue. What else we have? We obviously keep maintaining our own demolition licensing regulations with some changes. It can also drill down to the individual regulation level. For example, in Western Australia currently you can only get asbestos tested at NATA approved laboratories. In the model you can get them approved by the regulator. Now we don't have the facilities to do that, tested by the regulator. We don't have the facilities to do that, so it will still continue to be just NATA approved laboratories for testing of asbestos. So that's just an example of the kind of things that are changing. And we do have a document that is currently on the website that provides an overview of the regulations. You can find some of the changes in there, but obviously most people want to have a look at the regulations themselves to see them.
Will there be a training requirement for those working within a business as a health and safety manager or advisor?
The short answer is there's no regulated training requirement for that particular role. Obviously that's a decision that's going to have to be made by the individual business to meet their needs. The majority of the training that's in the regulations is a lot of it's vocational. It's around things like high-risk work licenses, high-risk diving work, and so on, and they're mostly in the VET sector. So individual businesses will need to make their own decisions about the level of training required, unless that role also includes roles such as operating a forklift.
Will there be a comparison table made available outlining amendments to regulations?
It's on my to-do list. Obviously we need to get the regulations out first. Once we get those regulations out, then we can start working on supporting material like that.
Will sexual harassment or assault be a reportable incident or notification?
Look, that's going to. We don't currently have a regulation that has that level of specificity. So you'll need to be looking at the notification requirements in the WHS Act itself, and whether there are elements of that that are already covered under those notification requirements, and clearly they will be notifiable to us. There is some work going on in the national arena around mental health. Obviously there's some work going on in Western Australia around the issues on mine sites. I'm not across those. I don't know if Bill has anything to add. No. Yeah, so there isn't currently intended to be a requirement with that level of specificity, but obviously there is a requirement in the WHS Act if someone has to be off work for a certain level of time as a consequence of that. And it doesn't hurt to tell us something, to report if you're not sure.
Do the new regulations require 2 yearly or annual hearing tests for noise-exposed workers?
I'll give that one to Bill.
So I'm not sure, I think the regulation is number 58 or 59, something like that, and it prescribes a 2-year period. So if you have a look at the noise regulation, that'll give you the details that you need. Will those that have recently completed a Certificate 4 in WorkSafe need a refresher course for the workplace?
Sorry, could you read that one again?
Yes. Well, okay. So will those that have recently completed a Certificate 4 in WorkSafe need a refresher course for the workplace? So I think the answer is that the work health, in terms of a Certificate 4, that's not something that's prescribed in the work health and safety regulations, but we would encourage you to obviously maintain your training and update it as is appropriate. When I import equipment from overseas, will I still need to make sure it meets Australian standards, or can it comply with foreign ones like in New South Wales? You have to be careful how you read that.
Look, the number of Australian standards that are referenced in the model regulations were reduced quite significantly during the development of them, and we've obviously reflected the model regulations in that regard. But the important thing to state here is that the Australian standards are what is the standard of safety for things like design of plant and so on that are accepted in industry in Australia. And that means that it would be reasonably practicable for someone to comply with those standards, even if the regulations don't specify that you have to comply with them. Now, obviously, if you're looking at plant imported that complies with overseas standards, you need to make a very careful judgment as to whether or not those standards are up to scratch in comparison to the Australian standards.
Have any of the storage of dangerous or hazardous goods rules changed?
Well, dangerous goods is going to continue to be regulated under the dangerous goods legislation. None of it's being, in fact, we went through an exercise of removing as much as we can to prevent overlap in the WHS general regulations, and where possible to duplicate the requirements. So I believe there's a definition of container which talks about 500 litres or 500 kilos currently, and we're just reflecting that. So I don't have the level of detail that I think would give a good answer to that question, but the general answer is that dangerous goods will continue to be regulated as is.
Can a PCBE be prosecuted if a member of the public has an accident in their workplace, say a shopping centre or car park?
So this is more of a question about the Work Health and Safety Act itself, and there is a duty to other persons at the workplace. Other persons at the workplace does include customers in a shopping centre. So if there is a causal link between safe systems of work put in place by a shop owner, for example, and those safe systems of work turn out to not be adequate, then there may be a case to answer, given that we have to establish beyond reasonable doubt there was a causal link between what was unsafe and what resulted in the injury. Slippery floors is a really good example. Slips and trips are something that is unfortunately still very commonly occurring. If a safe system of work wasn't put in place to deal with water on the floor in a shop or in a restaurant, and a customer slipped on it, then there may be a case to answer in terms of that you have failed your duty to other persons at the workplace. I should add that other persons, including customers, also have a duty to take reasonable care of their own safety and to follow reasonable instructions too. So if they ignore the signs that you've put up saying don't walk here, it's not safe, then it's less likely that you would have a case to answer. We tend not to try and litigate very specific examples such as this, because it is ultimately a matter for the courts, but in general, you have to remember that the standard of proof for offences under the Act is very high, and we don't conduct all that many prosecutions a year.
We would also say that if you're complying with your occupational safety and health duties now, under the Work Health and Safety laws, you'll still be complying. So, in effect, there's probably no substantive difference between the two laws. As an HSR, the lack of prescription in the Safe Work Australia regulations makes it a lot harder to confidently write PINs. Will there be more help available for HSRs?
Bill might be better answer.
So, in fact, next week there will be a Safety and Health Rep webinar, much the same as this, so there'll be some information provided there. But yes, we will be supporting health and safety representatives. The government has made it quite clear its support for the health and safety representatives and the roles they play. So yes, there will be information and assistance. Has there been a change to health monitoring for workers working with hazardous products?
So in terms of hazardous chemicals, for example, there have been a couple of changes to bring the model regulations into line with what currently happens in Western Australia. So for example, the obligation to provide or alert provide the health monitoring report to the regulator under the model regulations is on the PCBU. In Western Australia, that obligation is on the medical practitioner, and an amendment has been made to maintain that system. So it's a medical practitioner that provides the health monitoring report to the regulator, and that applies also to lead and asbestos. The other change is in Western Australia, the threshold is risk for health monitoring, whereas in the model it's significant risk. So we're again maintaining what the Western Australian approach is, which is just risk.
Will all notifiable incidents result in the need to preserve evidence for several days, or will WorkSafe advise the need at the time the notification is made?
I'm not so this is another Work Health and Safety Act question. So the principle, what you're talking about is called it's the duty to preserve an incident site. So if you do have a notifiable event, then you do have a duty to preserve the incident site. We will be putting in systems in place where it'll be fairly straightforward. That site has to be released by an inspector, and in most cases, I don't know what's happening administratively, I'm sorry, it's not my area, but I imagine that we'll be putting systems in place so we can respond and release those as quickly as possible to minimise disruption. Of course, if it's quite a significant incident involving a serious injury or significant near miss or unfortunately a fatality, then it's less likely that we will want to release that site until we've had a good look at it.
Will there be a moratorium on inspectors issuing PINs during the transition period so small business can get up to speed without heavy-handed enforcement?
Look, that's a matter for the regulator, who's the WorkSafe Commissioner. I'm not involved in the discussions in that area, but I understand that the focus in at least the first 6 months will be on education, if not longer, rather than issuing an improvement notice for something you may not have had the chance to comply with yet. That's just a natural thing that you do with new legislation, is you want to get people to comply voluntarily, so you educate people about how they can comply. Now, that doesn't mean that we won't be taking action if there are serious or significant issues that need to be fixed. We will still have the option to issue improvement and prohibition notices, but as I understand it, the initial focus will be on education.
We're receiving quite a number of questions in relation to the Work Health and Safety Act, and Andrew's answered a couple of those now. So the next questions, or the purpose of this particular presentation, is obviously in relation to the Work Health and Safety regulations. So the focus of our questions that we'll be responding to will be in relation to the Work Health and Safety Act. We will nevertheless, Work Health and Safety regulations. We will nevertheless keep those questions in relation to the Act and provide information in due course. But the focus at present is going to be on the regulations. Will there be a bulk registration option for classified plant previously exempted and now required to be registered? So this issue is a live issue within the department at present, and we are working our way through those issues. I suspect Anil probably had that question on Tuesday, but the department will be providing information as quickly as we can about that. Are you able to expand on health and safety service provider requirements that may be detailed in the regulations?
So you're talking about the requirements for service providers under 26A. If that's the case, no, there are no additional supporting regulations that support that duty under the Act. We are, however, shortly going to be releasing some interpretative material to help people better understand their duty under 26A. That would be another one of those Act questions.
Will design verifiers and competent persons need to be a registered engineer like in Queensland, or can anyone off the street do this?
There are some requirements around it. I really don't have that information to hand. We'll endeavour to answer that question.
So, as I mentioned in my presentation, in Western Australia, design verifiers, etc., they will need to be, I didn't mention it design verifiers will need to be registered, eligible for registration with the Engineers Institute. Can you please clarify under secondary smoke exposure, it will now be illegal to smoke cigarettes in commercial vehicles above the company's policy? I don't quite understand that, but in relation to smoking in commercial vehicles, the work health and safety regulations don't allow that now.
I suppose the question could be in relation to second-hand smoke if someone steps into a commercial vehicle having smoked outside. The requirement will be to manage the risk of and not expose as far as reasonably practicable.
Is the requirement to report incidents forthwith in the regulations as it is no longer in the Act?
Forthwith, I think literally we just changed the language, and I don't have the Act ahead of me, but the Act, most of the notification requirements in the Act, and I would refer you to the Act in terms of the timeliness. The only additional notification requirements in the general regulations relate to certain things like occupational zoonoses. So we don't use the language forthwith anymore.
But you end up at the same point?
Yeah.
Are we moving away from Australian standards for risk management?
Look, the philosophical design reason when the model regulations were designed to move away from referencing directly or requiring compliance directly with a specified Australian standard was one of the, it's just a general principle of law that to be able to comply with a law, you have to be able to understand your obligations in a law. And of course, there are some issues around actually getting access to Australian standards that you may be required to comply with. So the decision was taken during the development of the model regulations to reduce the number of standards referenced. Now that doesn't mean that they cannot be used to determine what's reasonably practicable. I think as we've mentioned earlier in terms of design standards, the Australian standards would be taken to be what is knowledge in the industry of what's the minimum to comply to make things safe. And we always, of course, encourage people to do better than the minimum. Sorry, can you just read the end of the question again?
What are the standards and codes of... sorry, it's gone.
Sorry, I'm sorry. If we haven't answered that question appropriately, we'll answer it probably in one of our FAQs. I'm sorry about that.
What other standards and codes of practice are referenced in the new regulations? Schedule 1 of the current regs references numerous standards.
So off the top of my head, I couldn't tell you, apart from a few. The only standard it's purely off memory, so I apologise, I don't have it in front of me. The only standard that's referenced in full in the work health and safety regulations is the diving standard, the occupational diving 2299 for high risk diving work. The vast majority of the other references to standards in the WHS regulations are generally just definitional. For example, we refer to the noise standard when we're talking about the definitions of noise. So there is no schedule of 50 to 70 something standards being referenced. They're just embedded in the model regulations themselves. There aren't too many of them.
Yes. But as Andrew mentioned earlier, the Australian standards are nevertheless the minimum threshold generally, although we can use other standards. Can you please talk about the new industrial manslaughter provision and how that may be detailed in the regs?
There's nothing in the regulations about industrial manslaughter. Offences of that nature are just in the Act itself.
What will the regulations provide in relation to infectious diseases like COVID-19? Will this address vaccinations at all?
Vaccinations are a general duty matter. What's currently specified in the regulations, as I mentioned a little while ago, is just in regards to occupational zoonoses. So that's the diseases that you can get from working with animals, for example. I don't know if any level of work's being done outside this project in terms of matters like COVID-19. But when it comes down to vaccinations, there is a primary duty of care in the Work Health and Safety Act to make sure that your people in the workplace, whether they're workers or other persons, are not exposed to hazards, so far as is reasonably practicable. So even without additional things like vaccine mandates that sit outside the work health and safety law, duty holders still have to think very hard about making sure they don't expose workers or other persons to hazards, and that'll be a matter for them to make that decision.
Notifiable prescribed illnesses and injuries are not in the model regs. Will they be in the Work Health and Safety Regs WA? They are slightly different in all states.
Yeah, as I mentioned, occupational zoonoses, and there is another list. I'm sorry, don't have it handy off the top of my head, but we modelled it straight up on the current requirements under the OSH regulations.
And the Work Health and Safety Act specifies the notification requirements as well.
Yes, a lot of the notification requirements are actually in the Act itself rather than the regulations. So things like serious injury, broken limbs, if you're going to be off work for 10 days, etc., in the Act itself.
Will there be any changes to working at heights, and if so, what will they be targeted at? For example, falling from one level to another rather than a metre value.
I think you might be more up to speed on where we are with that.
So the Work Health and Safety regulations don't specifically prescribe requirements in relation to falls from heights. There are some falls regulations, and they are detailed in the Work Health and Safety regulations. But there is, of course, a general duty in relation to falls from heights as well. Will the mining regulations be out by November as well? Well, I think Anil addressed this comment in his presentation. The expectation is that all of the Work Health and Safety regulations will be available at the same time in November. Are the construction industry white card requirements unchanged?
Off the top of my head, yes, they're unchanged from what currently exists in Western Australia.
That's correct. Does a spotter of a high-risk work activity that requires a licence need to hold the equivalent licence for the equipment that they are spotting for example, a forklift?
I don't have an answer to that one. I'm not that familiar with the requirements of the individual high-risk work licences.
So in relation to the high-risk work licences, there is a requirement that the operators are licensed, of course, but I'm not aware of any requirement for spotters to be licensed. We'll check that anyway, and we'll include that in the questions that we develop later on, answers to questions.
Of course, it doesn't mean that even if the regulations don't specify a minimum standard or do specify a minimum standard, it's still open to a workplace to impose a higher standard of safety.
Is there a list of available codes of practice? The Commission for Occupational Safety and Health is currently reviewing the various codes of practice. There are 21 or 24 model codes of practice. Most of those are being adopted in Western Australia, or that is the proposal, and some of the existing occupational safety and health codes of practice will also be coming across under the Work Health and Safety regulations. And once those lists are finalised, of course, we'll make those publicly available. Will those who have completed health and safety representative training need to be retrained?
The Commission for Occupational Safety and Health, training courses for health and safety reps are a matter for the Commission for Occupational Safety and Health. Clearly there are some differences between the WHS Act and the OSH Act in terms of duties and powers, probably the main one being that HSR can direct the cessation of unsafe work. So obviously there needs to be some training in place regarding those new duties. Also some changes in terms of health and safety committees. That is really a matter for the Commission for Occupational Safety and Health, and I don't know, apologies, I don't know where they're up to in regards to working on that at the moment.
So this is a similar question. Will we see the new regulations transferred into training components, such as for health and safety rep 5-day training? The health and safety reps will still be required to undergo a 5-day training course. The final content of that course is still being finalised, but clearly it will involve reference to the Work Health and Safety regulations. So that's the long answer. The short answer to that question is yes, they will. When will we know more about transition timelines to prepare for the new legislation and train our staff?
The transitional regulations will form part of the regulations when they're released.
Are the codes of practice going to be compulsory like in New Zealand, or just suggestions like in Victoria? Do I have to follow the code of practice if it is too costly to?
So with codes of practice, and this is a situation in Western Australia at the moment as well, what they do is provide a minimum standard of what is considered practicable in a particular industry or in relation to a particular hazard. So you are obliged to follow that code of practice unless you can come up with something that is equal to or better than the systems proposed in the code of practice. The codes of practice will refer to regulations. Clearly you have to follow the regulations or sections of the Act that they follow, but if you can find a system that is superior or at least equivalent to what's in the code of practice, then obviously you're able to do that. It is important to remember that a code of practice is admissible in court proceedings as what is reasonably practicable for that particular topic, so that will always be the benchmark.
Is there a specific date in November when the regulations will be publicly released? The work health and safety regulations are being drafted, and until we get the final version of the regulations, we can't determine the date, but our expectation is that it will be in November. Is there a gap assessment tool that business could use to conduct their readiness assessment?
I think this goes back to the question someone else asked earlier about a comparison tool. That's again on the to-do list to get done, but we need to get the regulations done first and available for those who need to know what the detail are. So it's certainly on the wish list.
What guidance will be provided to businesses to implement the new work health and safety laws?
Well, I think Bill's already alluded to that we will be providing substantial guidance on our website, some of which is already available. I can't remember if he referenced, we have the Western Australia's Work Health and Safety General Regulations Overview 2021. That at least gives you an idea of what the content of the regulations are and what the topics that are covered are. That's already available on the website, I believe. There's already a guide to the Act available on the website, and we've been working quite a lot behind the scenes to get this more guidance material to be made available to help you implement it in your workplace. So if you are not already signed up to our newsletters, I would encourage you to do so.
So, do we need to comply with Australian standards or not? I am confused. Well, I think the answer to that is that the Australian standards generally reflect the body of knowledge in Western Australia, or in Australia in fact. So if you're looking at certain issues, the Australian standards should form the basis of what you know. The work health and safety regulations allow other standards to be used, but those standards, generally speaking, they must have as a minimum meet the Australian standards.
So it comes down to, unless it's specified in the regulations, you must comply if it's specified in the regulations. If it's not specified in the regulations, then it's your call, but you must be aware that as a regulator and as a general body of jurisprudence, we look at Australian standards and say, that is the benchmark for what is practicable. So if you aren't certain whether you should comply with the standard, you're probably safer complying with the standard.
Will the regulations that deal with exposure to secondhand smoke address disability support workers working in people's homes?
It's a general provision, but it applies to workplaces. So that will be your workplace, I would imagine. It's a very difficult question. Unfortunately, it's going to go down to the nitty-gritty. So I'll put that on notice and try and get an answer out.
Queensland added a significant number of clauses to the construction chapter of the Work Health and Safety Regulations. Is WA intending to add clauses to the model work health and safety regs?
Well, generally we have. We've already covered off a few of those. But in relation to construction work, my recollection is we have added a few things, but not a massive body of work. Certainly construction work wasn't the body of the work that I was doing. I just don't have the details to hand at the moment. So
those Queensland regulations are quite extensive. And at this stage, the government has committed to adopting the model work health and safety regulations. And there's no issue at present that I'm aware of in relation to adopting those Queensland regulations.
Yeah, I will add that we are continuing, we will be adopting our regulations for tilt-up construction work. They will be as part of the construction regulations. So that's an example of where we are modifying the construction regulations, but only in terms of what we currently do in Western Australia.
Can you confirm which version of the model work health and safety regulations are being used as the basis for the WA regs?
Okay, so there's a short answer and a long answer to this. The 2019 version was what was used for public comment, so that was our baseline for drafting the work health and safety regulations for Western Australia. Having said that, we were conscious of a few changes that were made since those 2019 regulations came out, predominantly around updating Australian standards that are referenced in the regulations, and we have gone ahead and adopted those sorts of changes.
Under the model work health and safety regulations, pressure equipment only needs to be inspected regularly. How often is regular?
I don't know. Bill is a boiler expert.
Boiler. So under the work health and safety regulations, you have general duties. So you'll need to refer to things like the manufacturer's instructions. The Australian standards also provide guidance, but the underlying system is that you must provide a safe system of work. And that means that you must take measures to ensure that you're aware of the particular requirements of the plant. So there are a couple of methods there that you can determine what regularly might mean. Will the safety and health reps that have just completed their mandatory training need to do a refresher for the new Work Health and Safety Act?
I believe we've answered that question. We're still waiting to see what the Work Health and Safety Commission, the Commission for Occupational Safety and Health, decide to do on that one.
What resources will be made available for agriculture and farm business to learn about and comply with the new regulations? Guides, webinars?
We can tell them about the grants, I suppose. I don't know.
So obviously, during my introduction, I mentioned that we're providing the webinars, on-demand videos that are, once Safe Work October is completed. We'll also be conducting seminars in the regions and in the metropolitan area. And of course, we are in the process of developing our guides for the work health and safety regulations as well, and they are also available on the DMIRS website. And perhaps if, there you go, you can see some details there. Work health and safety. Contacts, so the Work Health and Safety website there, you'll find information, and that will be updated as we go, as documents become available. The general regulation overview is on the website, thank you. When will the mines and petroleum regulations be available for review prior to the implementation? As I mentioned earlier, our colleagues from the Mines Division provided a presentation earlier on this week, and they mentioned that the Work Health and Safety regulations will be available in the middle of November, or in November. We already have this publication, which is available on the WorkSafe website, which is the overview of the Work Health and Safety regulations. The mines regulations are working on a similar document, which will largely be based on this, but of course reflect the details in the Work Health and Safety mines regulations. So that document is being prepared. Will the old blue card recipient be required to change to a white card?
I don't have that transitional measure in front of me. I'm sorry, I'll have to have a look at it.
For the next question, the WorkSafe Plan Workbook is currently under review and will be released for the first half. Oh, sorry, I've marked that up, haven't I? Will there be a... I've confused myself with this, sorry. Will there be a mechanism for resolution in the event that mines regs conflict with the Work Health and Safety regs?
Sorry, what was that?
Will there be a mechanism for resolution in the event that mines regulations conflict with Work Health and Safety regs?
Well, there shouldn't be... Well, the intention is not to have any overlap. But that will depend, obviously, on the nature of the scope clause, and the scope clause will be the very last thing we draft. So I'm not sure about a mechanism, but of course, any decisions that is made can be subject to review. That's just a general principle of the Act and law. So I don't think that technically answers your question, but there is not meant to be much in the way of overlap. So
the Work Health and Safety Mines regulations will appear in Chapter 10 of the Work Health and Safety regulations. So the regulations applying in the mines regulations and general workplaces will be the same apart from Chapter 10. This is the question that confused me earlier. When will the WorkSafe plan tool be updated to reflect these changes? The WorkSafe plan workbook is currently under review and we expect it to be released in the first half of 2022. If there is something that is currently referenced in an Australian standard but there is no code from Safe Work or WA, then you would use the standard. There's many Australian standards and only a limited number of codes. So the work health and safety regulations are your requirements, and of course the Australian standards and the codes indeed can be used to help you comply with those work health and safety requirements. Do you want to add anything?
No, I think that's fine.
Queensland has made a large number of changes for theme park ride operators to the model regulations. Will we be adopting those changes?
We're adopting the model regulations predominantly, with the vast majority of the modifications being to bring them into line with what we currently do in Western Australia. That doesn't mean that we're not aware of what's being done in other jurisdictions, of course, but predominantly we'll be looking at adopting the model, and I don't believe the model. It's got a couple of things in there. I'm sure someone will correct me if I'm wrong. There's something about rope lines and so on, and of course any amusement device is an item of plant, so those general plant regulations will apply. But there isn't a chapter or a part on amusement devices in the general regulations for Western Australia.
Will there be any regulations in relation to working with children?
Not that I'm aware of. Just regulation. There is a regulation regarding persons under 16 not dealing with certain types of chemicals. That's the only one I can remember where we talk about age. In terms of working with children as a teacher or a health or a care provider, there aren't any specific regulations. I should, of course, remind everyone that the primary duty of care in the Act is a prominent duty for all of this law. So even where there isn't a regulation that covers your specific workplace or a specific type of work activity or a hazard, then the primary duty of care still applies.
Has the requirement for pressure vessels to be registered with WorkSafe been removed in the new work health and safety regulations? No, they haven't, and I'm operating on my memory, but I think around about regulation 289 is the plant regulations, and it's quite clear about the registration requirements, so they are maintained. None of our employees want to be a safety rep. Do we have an obligation to keep offering this opportunity to our staff?
Again, this is more of a question that relates to the Act, and the Act works by having someone make a request to have a health and safety representative. So if you can't find anyone to be a health and safety representative, then there's no obligation for you to have one. And I'm pretty sure you can't force someone to be a health and safety rep. Obviously, we would encourage people to be health and safety representatives. It is more work, I understand, but it can be quite rewarding. And we do provide, as mentioned, quite a bit of support for health and safety reps. But as a person conducting a business undertaking, if you would like to have a health and safety rep, then have a look at how you may encourage that, would be what I would suggest.
And along a similar line, will the new laws mean an OSH committee will be compulsory?
Again, it's something that is formed on request and by negotiation and consultation.
If a PCBU appoints a principal contractor, can the PCBU dictate the management systems and processes and risk controls the principal contractor must use?
That's going to be a contractual matter. Certainly the person appointing the principal contractor, saying the builder or whatever, I'm not very familiar with construction work, would have duties. Those duties would be to the extent of their influence and control, and that may well flow through to being requesting certain safe systems of work to be implemented as part of meeting their duties at the workplace. But I mean, obviously, both those parties have to meet their duties under the Work Health and Safety Act. You cannot contract out of them. But I don't know if you call it a builder or, the developer or the project manager, does have duties, and they can certainly request anyone that they contract to do the work to implement safe systems of work that they believe is necessary to meet those duties.
So the work health and safety laws are based on consultation, and this is very much an issue that should be consulted between the parties as well. When will there be more information for education providers so they can help people prepare? So as we've mentioned, the work health and safety laws, the regulations are being finalised. Our expectation is that the work health and safety regulations will be available in November, and certainly we can finalise and provide as much information as possible at that time. In the interim, we are already publishing various documents available on our workplace, on our worksite. I should also mention that that there are peak industry bodies, so these are employer and employee associations that have been provided funds by the government to conduct consultations. So these peak employer and employee bodies will be out and about doing their thing, and in addition WorkSafe will be as well in the very near future, but we're getting as much information out as we can.
I think it's also worth saying that the model regulations are available for perusal online at Safe Work Australia, and if in conjunction with the guide that we've already referenced, if you just want to get an overview of what's in there, then looking at the model with the guide handy will give you a fairly good idea. It's only, of course, when we get down to the nitty-gritty detail of the requirements that you'll need to wait for the Western Australian version of the general regulations.
Will there be a change to inspection periods for height safety equipment? Currently the regs notes 6 monthly if regularly used, whereas other states have 12 months.
Yeah, I don't know, I'm sorry, I don't know the answer to that.
I have to admit I'm not aware of that particular prescription in the regulations, but that'll be a question we can research and respond in due course. Where do we locate that document you are referring to and holding up? The information I have is that it is on the DMIRS website, and you've got the correct site there. So if it's not there now, it will be there in the very near future. But as I say, I'm sorry, the information I have is that it's there at present, and I apologise if it's not, but it will be up there very soon. What resources will be made available for agriculture and farm businesses to learn about and comply with the new regulations, guides, webinars? I think we've covered this one. Answered that one. We only have a few minutes left, we only have a short time left, so we'll just close off, and there are a number of questions in the queue, and as I mentioned a couple of times, we'll endeavour to answer those questions and provide those details on our website.